Good morning. Welcome to Learn with Lorna 140. My name is Lorna Steele-McGinn. I'm the Community Engagement Officer with the Highland Archive Service. And the Highland Archive Service has 4 archive centres across the north of Scotland, in Inverness, in Wick, in Fort William and in Portree. And together the four of us buildings look after historic document collections relating to the Highlands of Scotland and to certain of the islands. This series is brought to you by High Life Highland at no cost to the viewer. High Life Highland is a charity registered in Scotland, and there's no payment or subscription required to take part in this series of talks. But if you're able to donate towards our work, then we're very grateful for that. And as I always say, I know it sounds like a kind of empty sentence when you say things again and again, but we really do appreciate it, so thank you. Thank you for your comments last week about Sylvia Blaine's diaries. It was really touching to get messages and contact from people who were also kind of really touched by that story, so I'm glad. This week I'm looking at something very different. I'm looking at women in the court records. And I'm going to do something which I don't think I've ever done before, which is to put in a kind of trigger warning that I will be talking about quite a lot of violence, and I will be talking about violence against women and children. So if that's a subject that's difficult for you, you may not want to watch this one, but please just be aware that that will be something I'll be talking about. I've done previous episodes on court records, which you may remember if you want to have a look back at all the previous episodes. They're on Facebook, they're also on YouTube, to find those earlier ones. But I want to start again, as I always do, with a quick overview of what I mean by our court collections. We hold process papers for the Borough, Sheriff, JP and High Courts. So these are exactly what the word suggests. They're the process papers. They're not the main trial papers. Those are held at the National Records of Scotland. But these are the papers that kind of detail literally the process of getting somebody to trial. So whether that's the arrest, the piece of documentation that authorises an arrest, a warrant for arrest, something that might give a sentence because there's something that the local legal law enforcement had to do to make that happen. So that's basically the thing. It's the things that the local law enforcement had to enact to make the trial happen. For the Borough Court, the Sheriff Court and the High Court. And as I say, we do have other bits and pieces from other courts like the Admiralty, but those are the main ones. And those different types of court, I go into this in much more detail in an earlier episode, but just as a very quick overview, those different courts, the Borough, the Sheriff and the High, have different geographical jurisdictions. So obviously the Borough Court is self-explanatory, it's looking after the Borough of Inverness. There would be other borough courts as well. But they also had different legal jurisdictions. So, for instance, the High Court is dealing with the highest level of crime and therefore the most severe types of penalty. And today I wanted to focus particularly on women and how they feature in the court collections. We hold thousands of items in these court process papers, spanning hundreds of years. And women can be seen throughout them, although of course tend to be more men, but there are a lot of women in these papers. And rather than going through this as I usually would by looking at different types of court and then the different severity of crimes within those, I thought instead I would look at the women as they appear in these records. So women as victims of crime, women as perpetrators of crime, and then women who are people taking the law into their own hands, and I don't mean that in a bad way, making the law work for them as citizens, taking control of a situation and using the law, the weight of the law, to support them. So let's start with women as victims of crime. And we see this across all the different courts, the Borough, the Sheriff and the High, and they vary in severity. There are various examples. So there are, for example, women like Christian MacLean, wife of John Fraser, labourer of Inverness, who in 1754 complained to the Borough Court against Donald Shaw on a charge of assault and theft. In 1698, Isabel McMyer complained that Donald Noble and his wife had stolen from her. But the majority, so there are women who are complaining against theft, of things being stolen from them, things like that. But the majority of women that we see in the court records as victims are victims of assault by other women, by their husbands, by their landlords, by strangers. And again, as I'm aware that I've kind of put that trigger warning out for the first time to say that I will be talking about violence, I'm also aware that I'm using terms which today are quite incendiary. Things like victim, where we would now say survivor. But I'm going to stick to those terms, but please be aware that I am conscious of that. I'm going to start with a 1717 example. Catherine, I'm seeing your comment about the microphone. If you've watched before, you'll know this is an ongoing situation. All my things are at full volume, and it's something to do with it streaming through Facebook, I'm afraid. So here's an example from 1717, a complaint by Margaret Cuthbert and Lilias Noble. And this is how it reads. Complaint, Margaret Cuthbert, spouse to Hugh Fraser, tailor in Inverness, and Lilias Noble, spouse to Walter Ross, shoemaker, burgess of the said borough, against George Mackenzie, chapman there. Hugh humbly sheweth, so that's what they'll often start with, saying that this is what I'm here to talk about. We're here to say that. Whereby the laws and the daily practice of this and all other well-governed realms, the crimes of assaulting, beating and bruising the lieges, particularly within their dwelling houses, is expressly forbidden. So there are rules and laws that you shouldn't assault, bruise or beat the people who live in this kingdom, particularly within their own dwelling houses. It is expressly forbidden, and by the same laws severely punishable. Yet true it is, and of verity, that the said George Mackenzie, delinquent, shaking off all the fear of God and all the due respect of his Majesty's laws, did, upon the 23rd instant, assault, beat, and bruise the plaintiffs with his fists, the one within her dwelling house, and the other within Drummuir Kiln, and would undoubtedly have murdered them without any cause or provocation, were it not that they were rescued by Christian neighbours. It goes on to say that the delinquent should be severely punished, not only in his person and means, but also to secure the peace to the plaintiffs and to the lieges, and to the terror of those who dare to commit the like in the time coming. So, whenever you're dealing with court records, of course you have to sort of wiggle your way through legal language, particularly when you're looking at something from 300 years ago. Although if anyone works in law, you'll know some of those terms haven't changed at all. But the gist of that document is that there are laws in place that should mean that people should be safe. They shouldn't be assaulted or beaten up, especially in their own houses. And that's something that we see a lot through this, that there's a real distinction between something happening in the street and something happening in your own house. So interesting there, a couple of points, that in order to do it, he has shaken off the fear of God. That comes first. Then he's shaken off the respect of His Majesty's laws. And it goes on to say that he would undoubtedly have murdered them if other people hadn't stepped in. And many of them end with that sentence that the delinquent should be sought and punished in his person and in his means. So a punishment to him and a punishment to his finances or his property, to secure the peace of the people who have made the complaint, and to secure the peace of anyone else living in the area, and also as a lesson to the terror of others who might go on and do the same. And in that one, he was punished by a financial fine. And that's an assault by a man whose relationship to those women we don't know. But in some documents, the relationship is clearly stated. So, for instance, in this one from 1699, Catherine Macpherson, spouse. She's the complainer. She's the spouse to Lachlan Fraser in Drakeys, and she is complaining along with her father Donald Gow in Drakeys against her husband Lachlan. And again, it opens with that similar statement that where the laws of God, the conjugal laws and the acts of Parliament and the daily practice of this kingdom say that the horrible and detestable infamy of beating, blooding, bruising by husbands their wives, and ejecting and casting them forth of their families, and the crime of assassination, invading persons in their own families and actual places of their residence, be expressly forbidden and highly punishable. So again, the outline of what law has been contravened interesting there, specific reference to husbands and wives, and the fact that that is conjugal rights don't give you that right. It's despite all of that, it is true that contrary to that, the said Catherine Macpherson being lawfully married these 3 or 4 years bygone with the said Lachlan, he, laying aside the fear of God and respect to his conjugal promise in marriage, daily and continually did beat, blood, and wound his said spouse, which she, out of affection towards him, concealed, until upon Friday last, being the 22nd instant, he, following his former method, did beat and bruise his said wife, tore her face and made her blue, as is evidenced by his tokens. So that's the marks of his, the bruises are visible as evidence. And she, for the safety of her life, ran to her said father's house, and then the said Lachlan, the husband, entered there to perpetrate his wicked desire in murdering his said wife, who, being refused access so the father-in-law refused the husband access to the house, and he took his father-in-law by the cravat and the throat to overtake his design upon his wife. Wherefore the father-in-law threw him out of the door. And it goes on again to say that this is Christian, unchristian, and unlawful behaviour towards his wife and towards his father-in-law in his own home, and he ought to be punished in his person and in his means, and again as a lesson to other people. There are some very, very brief witness statements underneath this, and a scrawled note at the bottom that says he was given a £100 fine, which would be about £10,000 today, and he was to be secured in prison until that fine was paid. But of course what we don't know is what happened to them after that. I think that that's a very, very vivid picture, written in the 1600s, of that situation, of her constantly hiding and concealing that violence until she couldn't anymore, and she ran to her father. And again, it comes back to something I've said so many times over the years, that documents might be 300, 400, 500 years old, they might be 2 weeks old, but there is a thread of humanity that doesn't change sometimes, that we can connect to. They are still relevant. So some of these crimes received financial punishment, fines. Others received custodial sentences, and many, like that one there, that you're held in prison until you've paid the fine. It really depends on the date of the crime and the severity. And it's not always noted on the documents, because that's not always the point of the document. If this is something that people quite often think, well, why doesn't it tell the whole story? And you're like, because when it was written, that wasn't the purpose of it. The purpose of some documents is literally to issue an arrest warrant, and therefore you won't find out what happened on the end of that, because that's not the purpose of it. And sometimes where the punishments are noted, they are not what we might expect. So some are very severe and heavy that we see as very disproportionate now, and some are very light. And again, it depends very much on what was seen as more serious at the time. So anything that is a kind of a moral crime, or something against God, or theft is treated quite heavily, whereas sometimes the violent crimes that we might think would be much worse are not always seen that way. And it's very interesting. I had a very interesting conversation when I was working in the prison with some of the lads in there about this, and about what they saw to be the most serious crimes, but that's for another day. In November 1808, George Ingram, who was a private soldier in the 6th Battalion of the Royal Artillery, was imprisoned following a charge of assault on various girls while intoxicated. And the document that we have for this records him drunk, going to the little green with a group of other soldiers, and it lists all the men that were there with him. And they saw several girls there, several servant girls washing out clothes. And the document records what happened, that George Ingram, sat down next to one of these servant girls, and that she told him she didn't want his company, and she wanted him to go away and go home. She wanted none of his company, it said. He said that he wouldn't go home until he thought it was proper. It then says, upon her desiring him to keep away from her, he expressed himself as follows, and I am going to swear, "Damn you for a bitch, if you don't be quiet, I'll give you a blue eye." and immediately thereafter he struck the said Mary Cameron a severe blow with his fist upon her temple or eyebrow, and after this the deponent, so the person giving the statement, she and the said Mary Cameron who were hit ran away to get away from him. And this little group of documents about this case includes a statement by Mary Anderson, who was the servant to Mrs. Mackintosh of Raigmore, who was one of those who was there. She was unmarried, she was aged 15, and she spoke about what she had witnessed. Being found guilty of this, Ingram was sentenced to 8 days in prison, a £2 fine, which is about £100 today, so interesting there, that difference between that other case. And he was bound over to keep the peace for 12 months on pain of paying a 200 mark fine, which is nearer £10,000. So again, the initial fine was quite small, but if he didn't pay it and he didn't keep the peace for a year, then a follow-up, much bigger fine. So we see women as victims sometimes in these records, and that's not, of course, to say that we don't see many men as victims in them as well. But we do also see women as perpetrators of crime and criminals or perceived criminals, and I use that word quite in a considered way, and you'll see why in a second. And as I say, again, I'm aware that these terms are quite incendiary, of what we describe as a criminal and what we describe as a victim. So we have examples of documents that accused women of everything from adultery to murder, with prostitution, debt and assault all in between those. And in this example, which is a warrant of imprisonment from our Sheriff Court papers, Margaret Mackay and Janet Macpherson are accused of an interesting theft. It's said in the document itself, quite unashamedly, that they are being held up as an example. And it does make me wonder whether how much the punishment depended on who you had affected by it, who had you stolen from. So this is the document. Unto the Honourable the Sheriff Depute of Inverness or his substitute, the petition of Alexander Macdonnell, writer in Inverness, Procurator Fiscal to the Sheriff Court of Inverness, so that's a legal role in Scotland, a high up legal role in the courts. And it says this is a case being brought in the public interest. Humbly sheweth, so again, what I want to tell you is that Margaret Mackay, daughter of Roderick Mackay, tenant in Drumsharden, and Janet Macpherson, servant to John Mackay, did upon Saturday the 26th day of July last, or upon one or other of the days of that month, so it's somewhere around there it's happened, enter into the possession of the lands of Achnacairn, set on and occupied by William Fraser Esquire of Colbokie. So they have broken in or come into the property owned by William Fraser of Colbokie, and did theftuously and feloniously carry away and cut and carry away a small quantity of grass, which they converted to their own use. The petitioner considers it only a duty that he owes to the public to bring before this court this case, so as to teach the county at large that however small the theft may be, it must not excuse the punishment. May it please your lordships to consider the above. So, it's really interesting when you kind of immerse yourself in the court records and see the variance of crimes and the variance of punishments. And as I say, it does make you wonder if it depends who you stole from. So these women are brought before the court, and the document says that they will be committed into the toll booth, so into the prison of Inverness, until they're brought for trial. And then we have the trial recorded later on. So as I say, it's not full details, but it's just a quick summary of what's happened. Inverness, the 11th day of August, 1800. The sheriff substitute having considered the foregoing petition, the person complains upon now, so that the people who have been complained about have now been brought and are present in the court. And it says that they have decided, they've explained the petition to the complainants, so they tell the people who are being accused, and it specifically says that the whole thing is explained to them first in English and then in Gaelic. And it says that they were charged with theft. And the sentence that's recorded for them at the end is that they should be put into the toll booth of Inverness, therein to remain until 6 o'clock in the afternoon of Wednesday, the 13th of August, then to be set at liberty. So they were held in prison for 3 days. So not a very heavy sentence, but still a publicly, they are being made an example of. So sometimes the crimes are small. They've broken in and they've cut some grass. There are also things like bark being stripped from trees and roots of trees being exposed to cause damage. So some of the things are very, to us, would be extraordinary to think of the court spending their time with them. There are examples of other, I say minor crimes, but it's all relevant. It's all relative to the situation. But there are crimes of slander, of abusive language. Then there are examples of theft, more than the theft of some grass. Largely when it's women, thefts of clothing and food and sometimes livestock. There are cases of women not paying debts, of refusing to vacate properties. And also, as we kind of move up the seriousness, there are examples of some violent and aggressive crimes, such as assault of a husband, which is quite interesting. I haven't seen many of those. But there is a husband saying that he lives in fear of his life because of the aggression of his wife. There are numerous cases of concealment of pregnancy and child murder. Now, child murder for many of these is not going to be of a child of 2 or 3 years. It's generally going to be getting rid of a baby. So let's have a look at some of these more serious crimes. There's a document from our Borough Court records from 1699, and I wanted to do this before I come on and talk about those heavy ones, just to show you why I specifically said that the term criminal and how we label someone is problematic. This is a document from our Borough Court records from 1699, and it records Janet Ross being accused of double adultery. And what that means is she has slept with 2 different men. And so she's brought before the Borough Court. And on being found guilty of this, the judge ordained that she should be taken behind a cart through the 4 streets of Inverness. So at the time that Inverness was just built on 4 main streets, and should receive 10 strikes from the hand of the hangman in each street. So she's to be taken, dragged behind this cart or pulled behind this cart right through the town. On each of those streets she's to be hit 10 times by the hangman, and after that she's to be banished from the borough, never to return again, on pain of death. And that's why I say sometimes, I mean, that's roughly the same year as one of those ones of the violence against women that I mentioned at the beginning. So it's really interesting because that is a moral crime. That's seen as something morally wrong. It's really interesting to see the difference between the punishments. And interesting to us of how those judgments have changed and how we see different crimes of different severity. Sometimes people's reputation as troublemakers preceded them and meant perhaps that the court was inclined to lean one way or the other. As in the case of Elizabeth Mackintosh and her son John McBain. In our Borough Court records from 1698 is this extract. Complaint: David Cuthbert of Drakey's against Elizabeth Mackintosh and John McBain, her son, and the Procurator Fiscal for His Majesty's interest. That when the said David Cuthbert wanted several of his sheep and wedders, so wanted as in is missing, so that he realises that several of his sheep have gone missing, and wedders are I can't remember the exact biological breakdown now, but it's sheep at a certain stage. So he noticed that he's got some sheep missing, and on Saturday last, the Saturday last bypassed, which I like the phrasing of, having got intelligence that the said Elizabeth Mackintosh and her son were known to be notorious thieves, he did send Donald Bain and his son James to search the said Elizabeth's house, to see if they could find any ground to pursue her, which Donald Bain, after search made, found a ram in the said Elizabeth sheepcot, after the same was taken and killed by the said John McBain, her son. We get a lot of the said. John McBain, who left the skin of the said ram in the burn above the house. So they've realised that they've taken a hunch that if you're a notorious criminal, maybe you're involved in this. They've searched the house, they've found the body of a ram and the skin of this ram above the back of the house. They then say that as they are known to be notorious thieves, and according to the several acts of Parliament made against theft, they ought to be punished by death and confiscation of their movables to the terror of others. So not only should they be killed, but their movable possessions should be taken from them as well. It goes on to say on the bottom of the document, at Inverness, the 27th of January 1698, in the presence of James McBain and John Mackintosh Bailies, appeared the pursuer with the Procurator Fiscal and craved process. So again, these are these standard legal phrases that you see at the beginning, that they're saying, you know, they've turned up and they want the proceedings to go ahead. Elizabeth Mackintosh confessed that her said son had brought the ram complained about to her house, and that John McBain, also being interrogated, confessed that he got the said ram dead in the burn and brought it to his mother. When this was considered, the judges ordered that Elizabeth Mackintosh be scourged at the cross. I hate that word. It's such a kind of visceral description. So she was to be scourged at the cross by the hands of the hangman, giving her 12 strokes, and her son to get 20 strokes, and they were ordained to be banished from the town and liberties, never to be returned again, under pain of death. So quite a heavy punishment. The stealing of livestock was a very, very serious offence and was punishable by death. And we might think that being banished would be horrendous. We have examples in our collections of being banished from the borough boundaries as well as being banished from Scotland as a whole. But there are examples of people seeing it as the better option and actually asking to be banished. An 1813 petition from the Borough Court details Janet Monroe and Janet Mackenzie, who were both held prisoners in the Tolbooth for attacking and insulting Major Robert Anstruther of the 42nd Regiment of Foot. They had attacking and insulting, in the common stairs leading up to the mess room. And it goes on to say that the petitioners with shame acknowledge being guilty of the offence and cast themselves on the mercy of the court, requesting that they be allowed to banish themselves from the borough of Inverness for whatever time the court sees fit. And the court met and said that they would grant this petition, and they banished them for 7 years. And if either of them was ever to be returned into the borough in that time, they would be whipped through the streets and put back outside the borough boundaries. Now, I have no idea of the circumstances of that. I have no idea of the guilt or the situation. But it does perhaps make you just wonder if these are two women who have been accused of insulting and kind of lashing out at a military officer on the stairs to the mess rooms. It does make you think back to that first one of all the soldiers with the women. I mentioned that there are quite a lot of murder cases which involve women, especially concealment of pregnancy. And I wanted to round off this bit by reading you an example of this from our High Court papers. In 1763, Anne Miller was arrested for child murder. And as I say, it's always, in the ones I have seen, it's getting rid of your own child. She was arrested on the information of Reverend Thomas Gordon, the minister of Auldearn, and was held initially in Nairn while awaiting trial. But we hold a petition and warrant for transmitting her from Nairn to Inverness because, and I quote, "The prison of Nairn is at present in a very ruinous and insufficient condition, whereby there is great danger of the said Anne Miller making her escape." And she was transmitted from Nairn under a sure guard to Inverness, where she was held until her trial. And when the trial was held, she was found guilty and sentenced to death. And we also hold her dead warrant. So very much seen as if you've taken a life, then you need to give a life. So some very, very heavy punishments and some horrendous situations for people to be in. I wanted to end though on a more positive note, because I'm aware that it's heavy, it's a heavy subject. There are examples of women taking control. There are examples of women making the legal system work for them. So for instance, there are landladies asking the court for assistance with tenants in the 1600s. There are women as employers looking for help with troublesome employees. There are petitions regarding maintenance of women and legacies of women, and some of those are written by men looking for support for their mothers or for their sisters or for family members who have lost someone, and the men are writing on behalf of the women to get what the women are entitled to, but also the women writing it themselves. There are examples of women asking the courts to intervene when buildings encroach upon the land that they own and that they want the court to step in. There are examples of women who step in to cause the arrest of a man who has broken into their house and threatened to shoot them. And he says that, that he will shoot them if they do anything to stand against him. And they have gone to the court and have given that statement and led to his arrest. So there are examples of strength, of courage, of bravery, as well as of suffering and as well as of violence by women. There's also an example of a housemaid who had the audacity to elope without giving notice in 1780, which made its way into the court records. But I wanted to finish by sharing with you one of the very few court documents that made me laugh out loud, because, as I say, I'm conscious that it's a heavy subject and it can't be anything but, really, because generally speaking in court documents, someone is a victim and someone is a perpetrator. So it is a heavy subject. But I wanted to share this one with you because it made me laugh. This is from 1813 and is entitled The Answers for Marjorie McEwen, alias Cameron, in dispute with Isabel Mackenzie. And it opens like this. This is brilliantly written. This is perhaps the most extraordinary action which has ever been brought before this or any other court. The subject matter which is introduced to the notice of your honours is no more than a petty, insignificant difference between an old woman and a maidservant about a hen. And this mighty matter is brought forward by no less a personage than the Procurator Fiscal of Court, with all the solemnity and importance of a major and a minor proposition, expressed with all the imposing dignity of an indictment, and concluding for inflicting the punishment of banishment, imprisonment, and americament, I think, and also for the expense of process. So he's writing saying, I can't believe I'm here. You really get that sense right through this document that he's going, I can't believe I'm here in the court talking about this argument between an old woman and a maidservant about a flipping hen. I can't believe this. And he goes on to say, this is absolutely irrelevant, but according to law, it is illegal to do certain things to people, including taking violently and forcibly from them the property in their possession. That should be severely punished, and especially when it happens on the streets of a royal borough. And he goes on to say, however, it can only apply when things were lawfully in their possession in the first place. And it's almost like he's going, okay, you've made me come here to talk about this, well, I'm going to take every point of law that I can to prove a point because you've made me come here to talk about a hen. He then says, even if we agree that the hen definitely did belong to the woman, it's still a pointless case because the law says that acts which are severely punishable are invading, assaulting, beating and bruising any of His Majesty's lieges. But the complainant says that Marjorie McEwen did attack and strike Isabel Mackenzie about this chicken, but she didn't beat or bruise her, so it doesn't count. And it didn't happen on the streets of the borough, it happened near a house on the brae above the fish market, and we don't know for sure that it was Isabel Mackenzie's hen in the first place, and Mackay just attempted to carry off the hen. She says, the writer says, This was not a full abduction of a hen, just an attempt to steal a hen. Your honours cannot fail to observe the manifest discrepancies between these points of law. He goes on to say, if any crime at all has been stated, certainly the offence is of the most trivial imaginable, and for this phantom crime, banishment or imprisonment are very modestly prayed for. So he's saying, so nothing's happened. Even if it had happened, it still wouldn't have been that important. But yet, you're asking me to banish or imprison someone for it. He concludes that the case is absurd and almost entertaining, but that the public prosecutor would do well to remember that the law does not deal in trivialities, and that he ought to seek more into the motives behind this case being brought to the court. He says that you ought to remember the dignity of your office and the respectability of your talents. These ought not to be employed to serve private pique. He then says, anyone who agreed to this being brought to court will now probably fall into a pit of their own making. He's quite the orator, James Beaton. I hope you've enjoyed that. I know, Linda, isn't it amazing? Attempted hen theft. Not actual hen theft, not a full abduction, just attempted hen theft. I hope you've enjoyed hearing some stories from our court records. There are so many that I could have picked, but I hope you have enjoyed some of those stories. Some are heavy and some are light to listen to. Annabelle, thank you for saying more talks, please. If you haven't caught the other 139, you can find them on our YouTube channel. But in the meantime, I will be back next week looking at further stories from women in the Caithness collections. So I'll look forward to speaking to you then. But a reminder that this series is brought to you by High Life Highland at no cost to the viewer. That High Life Highland is a charity registered in Scotland, and there's no payment or subscription required to take part in this series of talks. If you're able to donate towards our work, then we're very grateful for that. Thank you very much. Thank you for all your lovely comments. I'm really glad you enjoyed it. Thank you.